Hello, greetings everyone. Welcome to this summary for legal issues in information management. And we'll be dealing with first module one here, concept of cyberspace, cybercrime, cyber jurisdiction, and liability for statements. Under study section one in module one, we have the concept of cyberspace and cyber jurisdiction. To understand this concept, cyberspace Cyberspace refers to a virtual environment where interactions occur, transactions, communications occur, transcending physical geography, meaning it goes beyond physical geography. This term is coined by science fiction writer William Gibson. Please note this because you could be asked that the term cyberspace was coined by who? Fiction writer William Gibson. Describe It describes the interconnectedness between global digital network. Examples include online communities like Facebook, Twitter, where users interact without physical presence. Key characteristics of cyberspace, because we are discussing the concept of cyberspace now. First characteristics: interconnectivity. Communication and data sharing occurs worldwide through telecommunication network. Virtual nature. It exists without any tangible or geographical boundaries, unlike physical space like marketplace. Real space versus cyberspace. A real space involves physical interaction, while cyberspace consists of digital interaction. For example, real space transaction, buying a book from a physical store where buyer and sellers meet face to face. That is real space. Cyberspace, purchasing the same books from an online store like Amazon, like Konga, like Jumia, where the buyer and the sellers may be in different countries. This is it. We're moving down. We're done with cyberspace now. So we're moving to cyber jurisdiction. You see, jurisdiction refers to legal authority to govern or adjudicate a matter. Uh, a typical example is when you reside in I reside in Kano, for example, and where I reside, if there is a crime or an issue that I want to report, I have to go to the police station within that location. And I also have to look for the magistrate courts around that location, the nearest magistrate case. So that is the jurisdiction. So jurisdiction refers to the legal authority to govern and adjudicate a matter. In cyberspace, jurisdictional issues arise because activities often involve parties in multiple locations. For example, the seller might be in US and the buyer in Nigeria and the server in UK. So you see multiple jurisdiction. This is a typical example of jurisdiction in cyber case. So determining the applicable law and courts becomes complex. So that is why this jurisdiction issue. Because the case could be struck out in court just based on jurisdiction. The court you've gone to doesn't have the jurisdiction to hear the matter. Um, Example: Yahoo case, Yahoo versus ILICRA. French authorities sought jurisdiction over Yahoo for selling Nazi memo memorabilias, which is illegal in France, but permissible in the US. The case highlights the challenge of cross-border legal disputes. Study section 2. I hope you understand the issue of jurisdiction now. Jurisdiction is just cyber jurisdiction refers to the legal authority to govern or adjudicate. Adjudicate is means to hear a matter or to judge a matter. So, in cyber space jurisdiction, um, issues that arise are very complex because of multiple locations that might be involved, like this example we are showed now, where a buyer A seller can be in US, the buyer in Nigeria, and the server in the UK. It becomes complex because of multiple jurisdiction. Now we go to study section 2, talks basically about cybercrime and computers. Cyber and computer crimes. Defining cybercrime. Cybercrime is offense committed using a computer or a digital network. So it doesn't necessarily has to be a computer. Where a digital network, such as a phone, or MTN is a digital network, such as uh, you are using a tab, but it was committed over a digital network, meaning the network must have telecoms communications involved. It's a digital network. These crimes may target individuals, businesses, and governments. Types of cybercrime. We have identity theft, where someone steals another person's personal information to commit fraud or to use it for his own personal benefit, e.g., stealing credit cards for purchases. We have hacking, unauthorized access into a computer or a computer network. So unauthorized access into computer systems, such as breaking into a company server and stealing. So you see, you had access into the server, and the person stole from the server, but it might not be using the computer system of that organization. It might be using his own computer to break into a server or a digital network. So cyber stalking, sending threatening, obscene messages via email, social media platforms like WhatsApp, Facebook, Twitter, and so on and so forth. That's cyber stalking. You're sending threatening, you're stalking the person online. You have child pornography, using digital platform to distribute and store illicit material involving minors. These are 4 crimes, 4 types of cyber crimes. We move down here to key features of cybercrime. First, it has a global reach. Perpetrators can operate from anywhere, targeting victims across borders. For instance, the hacker is in Eastern Europe, might target financial institutions in US. That creates room for anonymity, because you don't even know where the person is working from, because they might hide it where they are working from. So anonymity, criminals might disguise their identities using proxy servers and VPN to deflect the place where the person is resident or residing. This would lead to difficult contact tracing. You can't trace who has committed the crime. That's why the nature of the crime is anonymity, and key feature. These are key features of cybercrime: global reach, anonymity. So the Cyber Act Crime in Nigeria 2015. I've read this document page to page, and this act addresses cybercrime by outlining offenses and their penalty. Unlawful access into a computer, access to computers, intentionally accessing computer network without permission is punishable by 5 years in prison and a fine of 5 million, or a fine of 5 million. System interference, disrupting computer operation is punishable by 2 years in prison and a fine of 5 million, or a fine of 5 million. Cyber stalking. So these are other computer uh, uh, cyber crimes you also know. Unlawful access into a computer, system interference, cyber stalking, which we talked about earlier, sending offensive and threatening messages online, punishable by 3 years in prison and a fine of 7 million, or a fine of 7 million. Child pornography, producing and distribution of pornography, punishable by 10 years in prison and a fine of 20 million, or a fine of 20 million. So um, we move down to study section 3, excuse me, thoughts related to electronic information. Definition of thoughts. Thought is a civil wrong causing harm or loss, leading to legal liability. In cyberspace, thought often involves issues like defamation, that's publishing false and harmful statements online. Example, posting fake reviews about a competitor's product to harm the reputation. I remember the woman who talked about, is it Maggie, or one issue, or one product did give a bad review about a product, and she was arrested in Niger State, having to spend a lot of time in prison. Uh, This I think it's for defamation. So invasion of privacy, sharing private information without consent. Example, a hacker leaking personal photos of a celebrity online, or personal photos of someone's private wedding party or private event. Even hacking a phone of your competitor. These are invasion of privacy. Even hacking someone's laptop and checking his private information and publishing them, leaking them to cause harm and to cause uh, loss to the person. This is invasion of privacy. Example, Campbell MGN Limited 2004. Campbell Naomi sued a newspaper for publishing details of her drug uh, rehabilitation without consent, highlighting privacy issues. So that is a big example. Let's go further to study section 4. Remember, this is just summary, so make sure you also read the material. But these summaries will do you a lot good to know what each study section talks about and how to handle questions that will come out from each study section. I think with this study section 4, maybe module 1 will be concluded. Liability for statement, defamation, and defenses. Liability for online statement. Digital environment allows rapid sharing of information, which could easily lead to liability if statements are defamatory and false information causes harm. Please note this: if statements are defamatory and false information causes harm. Defamation in cyberspace. Defamation involves making false statement that harms another's reputation. Example, false allegation of fraud posted on LinkedIn, false allegation of fraud posted on WhatsApp, publishing unverified stories on blog and news platform. This can be known as defamation in cyberface. Defense to defamation. This basically is telling you that if someone sues you for defamation, if someone said you have defamed them, one, if the statement is true, it is not defamatory. So, one, defense for defamation is truth. Two, fair comments. Opinions on matters of public interest, such as a product review or such as product reviews, are protected. Yeah, yes, if you make a public make reviews on products and things based with fair comments, and this must not cause harm and loss to the company that you are reviewing their product. So you must also be very careful. So that's why your comments must be very fair and less negative. Qualified privilege. Communications made in professional capacity. That is, for example, uh, if you are a medical doctor and a patient comes to you and it says it's taking Panadol made by XYZ and is still having headache, and you say, oh, so many complaints about people from my clients or patients taking XYZ Panadol, and they don't really get relief. Because you see, you're qualified, that's a qualified privilege because you're a medical doctor. They don't really get relief from this particular medicine, this particular Panadol. Why don't you try Panadol made from CCB? So you see, you have referred it, you have made that communication based on professional capacity, and you have now said, okay, try Panadol uh, made from CCB instead of XYZ. So that's qualified. It's your profession that really qualifies you to make that suggestion. So it's not as if you are defaming that product and it was done behind closed doors between you and the patient. So you don't expect to see this in the public or anywhere. So the qualified privilege. So you can find other examples. So these are the defense for defamation. Truth, one, fair comment, qualified privilege. Communications made due to professional capacity. Um, Made due to professional capacity. Like saying this author's book doesn't really explains author XYZ book on defamation doesn't really explain defamation properly. So you are a university professor making this suggestion to students that okay, try author ABC, and you will see that defamation is well explained in his book. You see, you're doing that as a professional in your professional capacity as a professor. Let's move down to study section 5. Okay, so this has study section 5. Reviews of case laws. Google Spain versus. Uh, okay, this session explores significant legal precedents in cyberspace related issues. You see, in law, there's what we call uh, legal precedents. Legal precedents, and the legal precedent is it's very simple. In law, all cases are judged based on legal precedents, like what has been done before. You follow that precedent to solve another case. So that is what we call legal precedents in law. So the case that has been judged before, adjudicated before, you follow that precedent to to solve another case. So that's why they are showing you case law. So that's why law uses the rule of case law. Legal precedent refers to principle and rule established in previous legal case that a court or a judicial body uses to decide future cases. So and types of precedent, binding precedent, so they're binding and mandatory. Decision made by higher courts are binding on lower courts, such as the Supreme Court on the appeal court, and on the appeal court on is binding on the high courts. And so examples, like I've just said, decision of the Supreme Court is binding on the appellates and the lower courts. So these are types of precedent. So we have mandatory and binding. We have persuasive precedent, not binding but may influence court decision. Comes from a lower court and other jurisdiction, other legal sources such as academic writings. So a court might analyze whether the facts of a case align closely with prior rulings. So what we call this is satire diasis, and that's in Latin. To stand by things that have already been decided, to stand by things already decided. This doctrine, which the courts adhere to precedent to promote legal stability. That is the main reason for case laws, to provide legal stability. So we call them satire diasis. Satire diasis. So overruling precedent, higher courts like Supreme Court or appeal courts. Supreme Court can overrule precedent by a lower court, which is the appeal court, and the appeal court can overrule precedent of the high courts, which is a lower court, or of magistrate court, which is a lower court. Overruling precedent, higher courts have the power to overrule precedent if they deem it outdated or incorrect. So you should understand this. So the importance of legal precedents, we talk about consistency, efficiency, and it serves for guidance. So this is it. So let's move down to notable cases. So Spain, Google Spain versus Angex Agencia in 2014. Issues: Spanish citizens sought to remove outdated financial information from Google search. The outcome: established the right to be forgotten, yes, allowing individuals to request the removal of certain personal data online. That is the final judgment. And you see, this will now set a precedent for other cases. If your data has stayed too long on a database for 2, 3, 4, 5 years, you can sue them and ask that you have the right to be forgotten so that your data can be removed there. Your personal data can be removed for online because it stayed there too long. DPP versus Lennon 2006. Issue: a UK defendant was convicted for sending spam emails disrupting business operation. And then the significance: demonstrated how traditional laws could be applied to modern cyber offenses. So Module 1 laid a foundation for understanding legal complexities in cybercrime through concepts, law of laws, concept, laws, and cases. So it highlights the importance for adapting legal framework in dynamic digital landscape. Let's go down to the questions and answer for this module 1. First, here we talk about what is cyberspace? How does it differ from real space? We've talked about it before. Cyberspace is a virtual environment where communication and interaction and transaction occur through interconnected digital network, primarily via an internet. Unlike the real space, there's no physical boundaries. It exists only in the realm of the digital. So that's how cyberspace differs from real space. The real space is like the marketplace, physical marketplace, malls, shops that you enter. That's the real space. It's real, it's physical, you can touch them. Key characteristics of the cyberspace is facilitate global connectivity and interaction without constraints of physical geography. It enables exchange of data, ideas, and service through platforms and websites, such as e.g. social media and website. So we talk about difference between cyber and real space. Real space transaction involves physical presence, buying a book from a local bookstore, buying goods from a physical mall. Cyberspace occurs digitally without face-to-face interaction, purchasing the same book from Amazon and Kindle and every on some other book stores. Example, a Nigerian user can access webinar hosted in United States in the cyberspace, an interaction that would physically be impossible in the real space without travel. 2. What is cyber jurisdiction and why is it a legal challenge? Why is it a challenge in legal system? Cyber jurisdiction refers to the authority of a legal system to regulate or adjudicate matters arising from cyberspace. It becomes challenging because cyberspace lacks geographical boundary, making it unclear which law applies to cross-border interaction. Key issues in cyber jurisdiction. We talked about multiple jurisdiction may claim authority over the same case, like UK or US claiming the same jurisdiction over a dispute or a transaction. Determining the appropriate legal system where users, servers, and businesses are in different countries. These are challenges for, these are key issues in cyber jurisdiction. So, types of types of jurisdiction: prescriptive jurisdiction, the authority to make laws; adjudicative jurisdiction, authorities to resolve disputes in courts; enforcement jurisdiction, which is authority to enforce laws and judicial decision. Example, the Yahoo case. And in Yahoo Inc. versus Lycra, the French court claims jurisdiction over Yahoo sales of Nazi memorabilia, which violated French laws, but it was permissible under the US law. The conflict highlights the complexities in applying jurisdiction in cyber case. Prescriptive jurisdiction, they make laws, they prescribe laws, they prescribe what is to be done, so the authorities to make law. They have the authority to make the law. Prescriptive jurisdiction. Adjudicative jurisdiction, the authority to resolve disputes, to adjudicate disputes that are in court. So that jurisdiction has the right to make and resolve dispute. Enforcement has the authority to enforce laws and judicial decisions, and also legal precedent. Remember when I was explaining legal precedent, I said there are precedents that the types of precedent that they are binding precedent. So you see the enforcement, when it's binding, it will be enforced by that court. So enforcement of authority, the authority to enforce laws and judicial decisions. Define cyber crime. Explain its key characteristics. Cybercrime involves illegal activities conducted through digital platform or computer. It encompasses a range of offenses that target individuals and businesses and governments. Key characteristic is global reach. Cybercriminals can target anybody from anywhere in the world across international boundary. Anonymity: cybercriminals can disguise their identity, making them very difficult to locate using technologies like VPN. Scalability: cybercrime can impact thousands and millions of people simultaneously at the same time and at different times also. Cybercrime can impact thousands, millions of victims. Example, identity theft, personal stealing, stealing personal data to commit fraud. Example, a hacker has used a stolen credit card details to shop online. Cyber stalking, sending threatening emails to intimidate a person. Ransomware attack, encrypting a company's data and demanding for payments, like blocking out a company from his own data, from his own server, and telling them to pay you before you open it for them again to have access to their information. That's that's the information they've kept. Maybe under knowledge management, they've saved and stored some information on on a cyber, on what do they call it, on cloud, and you're able to get access to it and block them out, or able to attack their server and block out their key information that they need to create value, and then ask them for money. So encrypting a company's data, demanding for payment for decryption. So that's like it's similar to what we call kidnapping. You have kidnapped the company's data, and then you're now demanding that they should pay ransom for decryption. So, so in cyberspace, in cyber crimes, we call the kidnapping of information, the encrypting of a company's data, and the demand for ransom as demanding for payment for decryption. So in the physical space, it's like demanding for ransom for release. So we go here, discuss Cybercrime Act 2015 and its provision. We have talked about it. This provides legal framework for combating cyber crimes in Nigeria. It outlines various offenses and their penalties, promoting cyber security and protecting critical national infrastructure. First, key provision: unlawful access to computers. Unauthorized access to computers, punishable with 5 years or 5 million naira fine. System interference, disrupting computer functions, is punishable 2 years in prison with a fine of 5 million or a fine of 5 million. Cyber stalking, sending offensive messages online, on WhatsApp, on social media, on Facebook, on X, is punishable in Nigeria 3 years in prison with 7 million fine. Cyber terrorism, it is accessing system for terrorist purpose, is punishable with life imprisonment. Also here not stated is it's child pornography using online platform. It is punishable by with fee of 20 million, or let me see the number of years imprisonment. I earlier talked about it. So it's punishable with 10 years imprisonment with a fine of 20 million. So that is it. That is the summary of Cyber Crime Act of Nigeria in 2015. Unlawful access to computers, system interference, cyber stalking, and cyber terrorism, child pornography, which attracts 10 years and or 20 million. Cyber terrorism, it's life imprisonment, punishable, accessing system for terrorist purpose. So a cyberspace operator failing to maintain user register may face penalties under the action of non-compliance. So a cyber cafe operator failing to maintain a user register may, so they came, Yahoo boys or cyber criminals came to use your cyber cafe to scam somebody and defraud somebody, and then their location is traced to your cyber cafe and they used one of your system. Because you did not take or maintain user register, these user register, like having their email, their names, and their ID card and their house address, these can lead to penalties, and you may face penalties for non-compliance. What is defamation in cyberspace and the defense that are available? We have spoken about it. Defamation in cyberspace space refers to publication of false and harmful online statements that damages an individual or organization's reputation. These include written defamation, libel in blogs, social media, and the others. Defenses, three defense. We talked about truth. If the statement is true, it cannot be defamatory. Fair comment, opinions on matters that are of public interest are protected, so they term it as fair comment. Qualified privilege, statement made under in a professional or legal context are protected if made without malice. So, an example here is a journalist falsely accuses a politician of corruption in an online article. If the politician sues for defamation, the journalist can defend his claim by providing the truth of the matter. Then it uh, then it can be said that the truth has set him free. So a typical example is Dele Fayotimi versus Afe Babalola, which one of the major thing is he wrote in his book that Afe Babalola corrupted the courts and Supreme Court of Nigeria and gain some judgment for his clients. And Dele Fayotimi was arrested with a priority granted bail. However, the way out is either a either the truth will set you free by bringing out the truth of the matter, and secondly, nobody is looking at it as a fair statement, and thirdly, nobody is looking at it as a legal a qualified privilege. As a lawyer, he made that statement out of qualified privilege because he was able to gain that privilege information. But however, they said that he has damaged the reputation of the Nigerian justice system, criminal justice system, and that's why they are charging him. And then Afe Babalola has said he has brought pain, loss, and damage to his law firm and to his reputation. So we must be very careful when, even if he has spoken the truth, and they say the truth cannot be defamatory. But in this case, the referring to his case, he needs evidence to back this statement to make it true. And usually in court cases, when you obtain evidence illegally, then it has no material value in court because all documents gotten to back up the truth must be CTC'd, must be from the court registrar, and it must be satisfied the true and original copy. It must be given to you by court. And these are the issues. And these are the issues. Fair comments, the matters of public interest are protected. Despite he spoke for public interest so that the Supreme Court will raise his bar, raise its performance, but however, it's not looked at in that light. So he must be very careful. Defensive or defamation might not really work in the physical space, because in the physical and the real life situations, because they are very hard to prove, very hard to prove. And defamation is easy to prove, but defense of defamation is very difficult to prove, very difficult to prove. So let me see. Explain the significance of case law in understanding legal issues in cyberspace. Case law just provides you real life examples of how legal principles are applied to resolve uh, cyber disputes, and this offers insight into judicial reasonings and the legal precedents, set precedents for future cases, which we know as satire diocese. I will spell the satire diocese for you. Is STARE, then DECISIS. It's the Latin word that stands for to stand by things decided. It's a doctrine under which courts adhere to principles to provide and promote legal stability. So, example, case law, Google Spain, SL, and Agencia. This case established the right to be forgotten, allowing individuals to request removal of outdated and irrelevant personal data from search engines. DPP versus Lennon 2006, a UK defender convicted of sending spam messages, spam email that disrupted business operation, showing showcasing the applicability of traditional laws in cyber offenses. So traditional laws also work for cyber offenses. These cases highlight an evolving nature of the laws in adapting to technological advancement. How does thought how do thought related to electronic information apply in cyber case? Thought related to electronic information involve civil wrongs that cause harm through the misuse of electronic data. Common thoughts are defamation, publishing false statement, invasion of privacy, invasion of privacy and private information without consent, negligence, failing to secure sensitive data. So these are thoughts. Like Naomi Campbell sued MGN Limited 2004. Naomi Campbell sued the newspaper for publishing photos of her attending dog rehabilitation without her consent. Rehabilitation clinic. The court held that the privacy had been invaded, even though she was a public figure. This example demonstrates uh, how legal remedies addresses harm caused by digital environment. Module 2, definition, objectives, theories of intellectual property. So we'll go into this. So we define intellectual property refers to the creation of minds, the creations of the mind, such as invention, literacy, literary, artistic work, design, symbols, names, and images used in commerce. So intellectual property laws provide creators with rights to protect and benefit from their work. You see, when tacit knowledge becomes explicit, meaning that it has been documented, it has been codified, it needs to be protected because of the efforts taken by those people to bring out tacit knowledge to explicit. And that is why they said the creation of minds, such as properties, intellectual property refers to creation of the mind, such as invention. You see, tacit knowledge is the one that resides in the mind, such as invention, literary, artistic work, and design, symbols and names, images used in commerce. So, so one objectives of IP rights. IP here is intellectual property rights. So intellectual property rights encouraging innovation, granting exclusive rights, IP incentives creators, IPR incentivize creators to innovate and develop new ideas. So it helps to incentivize, that's create an incentive for those people who are using the ideas of the mind to earn a living or to create something. You have created something from your mind, it must be protected that you should earn the benefit and reap the benefit. Economic growth, protecting intellectual property work promotes industrial and technological progress. So economic growth, a company can grow from it, a country can grow from it. Cultural development, safeguarding artistic cultural expression fosters societal enrichment. So jurisdiction of intellectual property protection, moral justification. Okay, here, sorry, justification for intellectual property, moral justification. Creators deserve recognition, compensation for their efforts. Two, economic justification. Protecting IP issues ensures fair competition and rewards investment in research and development. Simply here is economic justification. Protecting intellectual properties ensures that there's a fair competition. Not that I have created a movie, which is my intellectual property, and then it's just being recopied by another person and sold. I've created a book and someone just photocopies it and starts selling, and then it's not fair. So there's no economic justification. Moral justification, yeah, creators deserve recognition and compensation for their work. Theories of intellectual property. I'm not going down into the theories a lot, but I expect that everybody should learn at least 4 or 5 of the theories so that you can maximize uh, from this. So take it upon yourself to learn the theories. First, we have authoritarian theory. IP rights maximize social welfare by incentivizing innovation. Labor theory. Creators have the natural right to the fruits of their labor. That's labor theory. Personality theory. Protecting IP safeguards creators' personality and self expression. So these are just three theories, and you can go on. There are more theories. So I won't go into theories here much, but these are just summary of three theories here. And then we can see study section 2, overview of statutory and institutional framework in IPR. We have Copyright Act 1988 in Nigeria. We have patent, which protects literary work, music, and cinematographic works. We have Patent Design Act 1970 grants permission to prevention and protection of industrial design. Trademarks Act 1965 protecting distinctive symbols, logos, and names used by in commerce. So institutional framework here we have National Copyright Commission oversees copywriting administration and enforcement. Trademark Patent Design Registry, registered trademark and patent to protect industrial property. National Office of Technology Acquisition and Promotion, NOTAP, facilitate transfer of technology and intellectual property rights. So challenges in Nigeria's uh, intellectual property rights system, weak enforcement, low public awareness, inadequate resource for intellectual property regulatory bodies. So this is it. This is section 2. We move to section 3, emerging developments, international response and basic principles of copyright. So emerging development, digital technologies have expanded the scope of intellectual property issues such as online piracy and copyright infringement. The rise of artificial intelligence has introduced complexities in defining ownership and authorship. So international responsive World Intellectual Property Organization, WIPO, a global body that administers IP treaties and promotes IP harmonization across nations. TRIPS agreement of the WTO. This sets minimum standards for intellectual property protection and enforcement worldwide. Basic principles of copyright. These are the basic principles of copyright you should know. 3. One, originality. The works must originate from the creator and not copied. Fixation. The work. 2. Fixation. The work must be expressed in tangible forms such as written and recorded and in digital format. 3. Duration. Copyright protection lasts for a specific period, usually the creator's lifetime, 50 to 70 years, depending on the jurisdiction. Example, a Nigerian musician's song is protected under the Copyright Act, granting them exclusive right to distribute and perform it. Software developers have protection copyright laws under the original code. So this is it. So study section 4, reviews of case law. This study section reviews case law, significant cases, and illustrating the practical application in law. Copyright infringement cases examples of cases. So we have copyright infringement, a publisher reproducing an author's work without permission, leading to a lawsuit for damage because he has infringed on the copyrights of the person, copyrights of the person. So we see a publisher reproducing an author's work without permission, leading to a lawsuit for damages. Trademark dispute, a company logo similar to another brand trademark, resulting to confusion among consumers. That's trademark disputes. So these cases highlight importance of intellectual property protection, ensuring fair competition, reward creativity, and deterring unauthorized use of intellectual property. So with this module 2, you should be able to understand intellectual property and fostering innovation, cultural growth, economic development. It also highlights the challenges of enforcement and the evolving nature of the intellectual property in digital era. Let's look at the questions from this module 2. First, we talk about definitions, objectives, and theories of intellectual property. First, we say, what is intellectual property? We say it refers to creation of the mind. It's such as innovation, literary work, artistic design, and designs and symbols which protected by law to ensure that creators gain recognition and financial benefit for their work. That is uh, uh, that is a definition of intellectual property. Important, it encourages innovation. IP law provides creators with exclusive right, motivating them to develop new ideas, protects creativity. So, ensuring that creators profit from their work without fear of unauthorized exploitation, boosts economic growth, promotes industrial and technological advancement, leading to economic development. Example, a software developer creates a new app by securing copyright protection. They can prevent unauthorized copying and distribution of the app. What are the major objectives and justification for intellectual property rights? First, we talk about the objective to promote innovation by granting exclusive right, to ensure reward for fair works of the creator, to ensure fair rewards for the creator's efforts, and to support economic and cultural development. So, what are the justification? Moral justification: one, creators deserve a recognition for their work. Two, economic justification: protecting IP encourages investment in research and development. Social justification: ensure that there's a dissemination of knowledge while respecting the creator's right. Example, pharmaceutical companies rely on patents to recover research costs, recover research costs and fund future drug discovery. Three, explain the theories of intellectual property with example. IP, first we talk about the first IP theory here, intellectual property theory. Utilitarian theory: IP rights maximize societal welfare by encouraging innovation and knowledge sharing. So patents on medical devices encourage companies to develop life-saving technologies. That's utilitarian. It's social welfare, due to social welfare, uh, maximizing social welfare by encouraging innovation and knowledge sharing. Labor theory: creators have the natural right to a laborer is worthy of the fruits of his labor. So the right to enjoy the fruits of their labor. Example, a painter should own the right to their artwork because it results from their effort and skill. Personality theory: IP rights protect personal connection creators have with their work. Example, a musician reflects on their identity and creativity and deserving legal protection. So that is it, the personality theory. So, what is the statutory and institutional framework for intellectual property in Nigeria? Statutory framework: Copyright Act 1988, Patent Design Act 1970, and this copyright one is for protection of literary work, music, and artists. Patent Design Act is for innovation and industrial designs and for manufacturing industries and all the others. Patent Designs Act 1970. Trademark Act 1965 protect distinctive logos, names, and symbols. Institutional framework: first one, we talked about Copyright Act. It's the Nigerian Copyright Commission, NCC, administers copyright laws. The Trademark, Patent, and Design Registry registers and enforces trademark and patent rights. Then Trademark Act, the NOTA, promotes technological transfer and intellectual property protection. An entrepreneur registering their trademark with the Trademark Registry ensures legal protection against unauthorized use by competitors. Let's see question 5. What are the emerging challenges of intellectual property, especially in the digital era? Answer: emerging challenges. First, online privacy, online piracy, online piracy, unauthorized distribution of copyrighted materials such as movie, music, and other digital platforms. This is one of the emerging challenge of copyright and intellectual property rights protection in digital era. Two, artificial intelligence, determining ownership of work created by AI system. Three, cross-border issues, enforcing intellectual property across jurisdiction is differing with differing regulations. A Nigerian musician's song is pirated in an international streaming platform, complicating enforcement due to jurisdiction challenges as it's not in Nigeria. What are the basic principles of copyright and how do they apply? Three basic principles of copyright and how they apply. Originality, work must originate from the creator. An author writing a novel is entitled to copyright protection for his original story. Fixation, the work must be recorded and expressed in tangible form, meaning that the song must have been recorded in studio and qualifies for a song recorded in a studio qualifies for a copyright protection. So, not you come to Facebook and rant or just sing a song for 10 seconds, 30 seconds, and then you see another person singing it and you say you want to sue the person. No much effort has been put in it. You didn't go to studio, you didn't copyright it, and other things. So fixation, the work must be recorded and expressed in tangible form. Duration, copyright lasts for the creator's lifetime plus a specified period, e.g., 50 years or 70 years after death. Application: if an artist creates a painting, they hold exclusive right to reproduce, display, and sell their work. Then, what are the international frameworks for intellectual property protection? Key in the key international frameworks: World Intellectual Property Organization (WIPO), administrators uh, global IP, administers global treaties, facilitate international cooperation. WIPO, please don't forget about it. Key international frameworks: WIPO, which is World Intellectual Property Organization. TRIPS of the WTO is a WTO agreement, World Trade Organization agreement. It sets minimum standard for intellectual property protection, ensuring that uniformity across member countries. Yeah. And this might help to solve the issue of jurisdiction. Yeah, because it ensures uniformity across member countries. So if you have a jurisdiction issue, you sang a song in Nigeria and you see it's pirated in the UK or in the US, and if they are members of the WTO, meaning that there's a law that can help set minimum standard for adjudicating the case and ensuring uniformity across member countries. A Nigerian entrepreneur example, painted a patented invention is protected under TRIPS members countries. This is what I just explained, reducing the risk of infringement even in international domain. What challenges does Nigeria face in enforcing intellectual property? The first challenge is weak enforcement, limited resources and manpower to combat IP intellectual property violations. Low public awareness. Many creators are unaware of their rights and how to protect them. Technological gaps. Difficulty in monitoring online platform from infringement. So yes, they have technological gap. Pirated versions of Nigerian films are sold in markets and streamed online, undermining the revenue of the film industry. You see, the economic benefit to the country is undermined, and also to the personal individuals. How does Copyright Act 1988 protect creators in Nigeria? Copyright Act 1988 protects creators' right to exclusively reproduce, distribute, and perform their works. It applies to literary work, e.g., books and poems, musical works, songs and artworks, which are painting and sculpture. Example: a Nigerian author writing a novel can sue for damages if someone publishes the book without permission. Um, Provide examples of intellectual property disputes and their outcome. So, Copyright dispute. A musician sues a company for using their song for an advertisement without permission. The court awards grant damages to the musician for infringement. Trade dispute. A company illegally uses a logo similar to Coca-Cola, causing confusion among consumers who buy the product and think it's Coca-Cola product. The court orders the company the infringing company to cease the use and pay for damages to Coca-Cola because they have benefited from it. The lesson learned: these um, cases underscore the importance of registering and enforcing intellectual property rights to prevent unauthorized use and ensure fair competition. Module 3. Module 3. Here we're talking about fundamental rights, freedom of expression, and access to information. This will, I think, deal with the FOIB. Okay, so we talk about fundamental rights. These are basic rights and freedoms guaranteed to individuals, protecting them from unjust treatment. These rights are often enshrined in the Constitution and international agreement, such as the Universal Declaration for Human Rights. 2. Freedom of expression. Freedom of expression refers to the right to hold opinions, seek information, communicate ideas without interference. It encompasses various forms of communication, including speech, writing, and digital media, as long as you do not defame anyone with your freedom of expression. Then we have key example: freedom of the press, journalists reporting on government corruption without fear of censorship and retaliation. 2. Digital platforms, social media, sharing opinions about social issues. Limitation. Freedom of expression is not absolute. This is what I've just mentioned earlier. Restrictions exist to protect uh, to protect national security, public order, and rights and reputations of others against defamation. So limitations are for national security issue, for public order, and rights and reputation of others. So my best bet is, if you're writing a book like Deliver to Me in future, or a book about anything you know that is of public interest and can affect national security or public order, or rights and reputation of others, have it looked at by a legal team so that it will avoid defamation. A laborer is worthy of the fruit of his labor. So is the law. There is no the ignorance of the law is no excuse. So as you are worthy for the fruit of your labor, as the intellectual property rights and the theory of labor tells you, that when you write a book or author anything or provide anything of novel importance, that you are the first to benefit from it and the only one that should benefit from it, which is a laborer is worthy of his wages. So therefore, if you write a book and you express your freedom of information and you defame anybody in it, you will also enjoy the wages of the law. So this is something we should be all mindful and very careful of as information management students. So let's go on. Study section 2, history, definition of freedom of information. The concept of freedom of information originated from the belief that Nigerian government should operate transparently. Over time, many countries, including Nigeria, adopted the Freedom of Information Act, which promotes accountability to its citizens. Uh, Definition: freedom of information ensures public access to government held information, enabling citizens to make informed decisions and hold authorities accountable, like the budget presentation and several other things that are presented before the House are made public for everyone to see before decisions are being taken and informed decisions by the citizen. Nature of the FOI is the cornerstone of democracy, empowering citizens to participate in government. It covers wide range of information such as public spending, policies, and administrative decisions. Uh, and that's why they always have public press secretaries and who will always make this information or government policies made known in public, especially through a government journal or government statements. A Nigerian journalist requests budget details for public health project under the FOI to expose misuse of fund. So that is it. So study section 3, examples of expect exemptions under the freedom of information. This is what I earlier said, that the FOI has exemption. As we talked about, the freedom of information, freedom of expression has exemption, has limitation to balance transparency with confidentiality. These involve national security. They would not tell you the defense budget for the year. They will not tell you about national security. Military operations are secret. They are restricted. They are not for the public because of your enemies and other countries and other spies. So national security information that could endanger national security or defense, such as military budget, operations, and other things, are held as restricted. Law enforcement, protecting ongoing investigation, method used by law enforcement, police records for active, for example, police record of an active criminal case. Those will be held away from the public, law enforcement, even the police. Privacy, safeguarding personal data of individuals. Employee records from public offices are in public offices are exempt from disclosure. So employee records in public offices are exempt from disclosure. Trade secret, protecting property information from private company. So for example, a government contract containing confidential business information. So private companies, so they are saying protecting proprietary information of private companies. So section 4, review of case laws. So they are reviewing case laws here for practical application of freedom and access to information. So Freedom of Information Act. So first case is Nigerian Freedom of Information case. Civil rights groups demand access to government records on environmental cleanups in Niger Delta. Outcome: court orders the release of documents emphasizing citizens' right to access of information. Freedom of expression case, a scenario where journalists publish article criticizing public official. The official sues for defamation. The court upholds journalists' right to express opinion, provided the statement are factual and also not defamatory. Factual, that's truth, and also not defamatory. You have to be fair. And so, questions for module 3: what are the fundamental rights and their What are fundamental rights and their importance? Fundamental rights are basic freedom guaranteed to individuals enshrined in the Constitution or international treaties. They protect individuals from unjust treatment and ensure dignity and equality and freedom. Importance: it promotes justice. Uh, Protect individuals against abuse by government and institutions, foster equality, ensures everyone is treated fairly by law, strengthens democracy, empowers citizens to participate freely in governance. Example: a Nigerian constitution that guarantees right to life, freedom of expression, freedom of association, ensuring citizens can speak out against injustice without fear. What is the freedom of expression? What are its limitations? Freedom of expression is right to hold opinions, seek information, share ideas without interferences, including speech, writing, arts, and digital communication. The limitation: national security, speech that endangers public safety is restricted. Defamation laws protect individuals from false statements harming their reputation. Obscenity laws prevent the spread of offensive and the incidental materials. Example: protected expression. A journalist publishes factual article on government corruption. Restricted expression. Inciting violence through hate speech is prohibited. So, explain the concept of freedom of. Let me see the question here. Explain the concept of freedom of information and its significance. Freedom of information ensures public access to government held information, promoting transparency, accountability, and informed decision making. It's significant. That's important. Empower citizens, help provide people people to understand government actions and policies, reduces corruption, public scrutiny on record, deters mismanagement, strengthens democracy, ensuring that informed participation in governance in Nigerians. So in Nigeria, a journalist, for example, uses freedom of information to obtain spending records on public infrastructure projects and exposes financial mismanagement. What are the exemptions under the Freedom of Information Act? Where are they necessary? They are necessary exemptions that balance transparency with confidentiality. They protect sensitive information that, if disclosed, could harm the public or private interest. Key exemptions: national security protects military operations and defense strategies, classified documents on counter-terrorism plan. Uh, we have privacy, safeguarding personal data of individuals, employee medical records in public institutions. You cannot be giving out medical records of employees working for government. Law enforcement preserves the integrity of ongoing investigation. Police case files for active criminals. You can't publish, you can't make investigations public when it's still ongoing. You can't say because you have freedom of information, you know about the investigation that you have gotten, then you now publish it when it will destroy the integrity of that investigation. And that is why even in court cases, they ask both parties to refrain to speaking to media or publishing anything until the court case is done to avoid media trial. And trade secret protects private propriety information of companies and government contract. A company bidding details of a government project. However, let's move to 6. How does FOI promote transparency in government? FOI provides citizens with legal access of documents, ensuring accountability and reducing corruption. Ways which FOI promotes transparency: encouraging public scrutiny. The citizens can monitor public spending and policies, exposing mismanagement. Journalists and activists can use FOI to uncover misuse of public resources and public funds, empowering whistleblowers, support individuals reporting unethical practices. Example: a civil group in Nigeria requests document on environmental cleanup efforts in Niger Delta to expose delays and corruption. Sixth question: discuss a case that illustrates the application of freedom of information in Nigeria. A case example is journalist versus the public official. A journalist publishes an article exposing public official misuse of fund. The official sues for defamation. The claim and the report damaged their reputation. Outcome: that the court rules in favor of the journalist, stating the publication is factual and is in public interest, thus protected under the freedom of information. Lesson: freedom of information, freedom of expression supports accountability that must be exercised responsibly and ensured factual accuracy. Factual accuracy. Um, okay, let me go here. What are the benefits and challenges of freedom of information in Nigeria? One, it promotes accountability. Officials are less likely to misuse resources if their actions are transparent. Enhancing governance enables evidence-based policy making through informed public feedback. What are the challenges? Limited awareness. Many citizens are unaware of the FOI rights. Bureaucratic hustles. Bureaucratic hustles, we say agencies delay and deny access to information. Weak enforcement, lack of penalties for non-compliance undermines the act and effectiveness. So, example, activists may seek information on healthcare spending, may face delay from agencies unwilling to release their document. The role of case laws play, the role case law play in understanding freedom of information. Case laws, like we said, is for providing judicial interpretation and precedent, clarifying how freedom of information and expression apply in practice. For example, FOIA case of a Nigerian NGO sued the government agency for withholding spending record of COVID-19 relief fund. The court ordered the records to be disclosed and emphasizing that citizens' right to access public information. Defamation case, a blogger issued a, accused of defaming a politician was acquitted after providing statements were factual. These significance These cases highlight the importance of balancing transparency, accountability with privacy in governance. How does freedom of expression support democracy? Freedom of expression ensures that open dialogue, accountability are virtual for functioning democracy. Ways to support democracy: facilitate debate. Citizens can discuss and critique government policies freely. Protects minority voices, ensures that all perspectives are heard, preventing oppression. Encourages participation, informed citizens are more likely to engage in governance. Protests against fuel subsidy removal in Nigeria demonstrated how freedom of expression allows citizens to voice their concern and influence policy decisions. How does FOIA empowers journalists in Nigeria? It provides journalists with the legal tool to access government documents, enabling them to investigate and report uh, public misuse of fund and other issues they see. So enabling investigative reporting and public accountability. So, example, investigative journalism. Reporters use FOI to obtain records on government projects and uncover corruption. Just like there are some websites you go that you can get information of the money being allocated to your local government every month and how they are being spent and how they are being used. And so, evidence based reporting, ensuring accuracy and credibility by relying on official data. Example, a journalist access FOI to review the discrepancies in public spending on education, sparkling nationwide debates on education, debates and reforms on education. Thank you. Thank you. I wish you all well. Good luck in your exams.